which is enforceable by law, which becomes legally binding, is the valid contract. Typically have all essentials of a valid contract. Now, what are the essentials of a valid contract? We'll see in the upcoming slides. Free consent. We'll see that in detail. I'll just write it. Free consent. What is consent?
Approval.
Agreement.
I'm willing to do it. This is out of my control.
Agreeing to something.
Willing, accepting the
There is
proposal.
always a thin line between these
Will,
words.
sir,
Agreement is
Not agreement.
You say
Agreeing to
agree.
something.
Consent is something which is will.
Accepting the proposal.
Will.
acceptance is consent. Not denying is not consent. You came out from your society, you don't have a car, there's auto coming. You wave the hand, he just came in front of you, you sit it and gone. You made an agreement. You have not spoken anything. And you just ask where to go, go. And before that you sit it. What is that? Consent.
Consent is kind of acknowledgement.
You need to write no. You need to speak no. Consent can be proved without writing also. Not denying is also consent. Somebody gives you something, you take it. Then afterwards you say, no, I'm not told that I will take it, but you took it now. Okay. Free consent. The consent should be free. Free from what? That I'll tell you now after this. Capacity to contract. My example. Qutub Minar to Taj Mahal, that barter system. Possible? It's not in my capacity. I'm not authorized legally to do so. Lawful consideration. I'll give you 100 grams of cocaine. If you do this thing, it is a consideration, it's an agreement. But is it a lawful consideration? Is it allowed?
Against the law.
Against the law. Lawful object. Same example. Giving you the Taj Mahal. It's unlawful. It's a public property. You cannot give it to a person. Not void, which is an impossible event. That also I'll in the upcoming slides I'll tell. So these are the basic essentials of a contract. A valid contract should have a free consent of the parties, not with the influence, undue influence that we'll see in the last slides also. Should not be under influence. The capacity to contract, though both parties who are making a contract, they should be capable of making contract. Some 3-year-old kid should not make a contract. They should be, there are other conditions we'll take up. Lawful consideration, whatever they are giving to each other, that should be lawful. For what they are making the contract should be lawful, lawful object. And it should not be void. It should not be based on an impossible event. I'll give you 100 riyal, the day earth will collapse. It's an impossible event. In the records, it is impossible, right? So, no. Void agreement. Against to it, which is mentioned in section 2G of the Act, which is not enforceable by law. Not binding because it cannot be enforced by the law. It's not binding. Illegal in nature. Generally, not always, because there are some impossible events. They are not illegal, but they are impossible. So generally, void agreements are illegal in nature. Contracts to execute impossible events are also void, as I just given the example. Now types of the contract quickly. Voidable contract, third category. We've seen void, valid. Now what is voidable? Any idea?
Valid now, it can be invalid after.
Great. Something, and also something which is at the option of a party. Means I made agreement with you. You try to offer something which I can object in court of a law that it is a void. But still I do not so. I don't do so. I want to get the contract done for my benefit. I'm silent. I'm not going to court to prove that this agreement is void. So it is voidable at my option. Same way, if it is with you, you find something which is against the law in this contract, but you don't want to object for your benefit. So you allow it and you finish, let both of the parties do the work. Let's not raise any dispute. Let's go our home. So if you are allowing that, again, it's a voidable contract at your option. Okay. And the one which Vijay has said, the one which may be valid now, but in future it may become void. Any legal changes, any change in law we speak about. Same way, anything which is void is now, but we know in future it is going to be valid. That is also a voidable contract because it has tendency to be void. Valid at present, but later becomes void or valid. Okay, so valid may become void, void may become valid. That tendency is there. It is a voidable contract. Express. But he was asking oral. Oral contract, something. Yeah. Express is what? Oral contract is express or implied. Right. So whether you say in presence of a witness or you write as a document, it is express. What is implied? Any example? And this is a hint in this sentence. In the definition of express, there is a hint. Terms and conditions clearly specified in the contracts. Express promise. Oral or written. What is implied? With example, anybody? Okay, leave law. Say what is implied in English.
There is something.
Understood.
Without any terms and conditions,
Yes.
without expressly written.
Yes. Example from your construction site. Any example?
Say,
Price is all inclusive. Simple example. Accounts finance administration to बताओ. Price is all inclusive. Means the party who's giving service, he has to take care of supply, transportation, taxation, everything. So all inclusive you written. Is it express or implied?
Implied.
Price is all exclusive is express. But whether I need to pay tax, the reply to this question is implied. Clear? Another example. You will construct the wall. What is express? You construct the wall. What is implied?
Inclusive
Design.
design.
You say lump sum, make the wall. It should be as per this. It should be able to withstand this much of tension, compression, whatever you say in civil terms. Now, what is the task of that party? Only construction. What is implied? He will do engineering. He will bring the material. You have not written. You told I need a wall. So expresses I need a wall. Implied is majority of times, one like those of you who are negotiating with subcontractors especially, they say, sir, it is not written. In P&M also, it is not written. Why you are asking me to deliver? What do you say? That when I write, I need not to write everything. I need not to make it a complete Ramayana for everything for one task. Some things are express, some things are implied.
Implied will be having this inclusive of all, no?
Maybe it's the way you write, but you should. It's not always this way. The thing comes here is the reasonability. If you think that the thing is implied, it should be under that purview. Like the example of I have given that the wall you should supply the material, do the design. Now you ask the party to just install a tube well also alongside that wall. Now you say because you have to make the wall, is alongside the wall, you have to make it. No, it's altogether a different thing, right? You cannot say it is implied that you make it. So the question is reasonability. Whatever is considered as a general practice to be covered in that package is implied. Whatever is not written is not written. Okay.
So, but here the word construction used expressly, or I mean, used as a contractual word, or because construction generally means to build, not to design.
Okay.
So,
I told another
As
word.
an example.
I told another word when I said a wall. Lump sum turnkey. You say it's a lump sum, means everything is included. Lump sum turnkey project is turnkey.
Okay.
That's my job, nothing else. You have to give everything as a lump sum price.
So can we move before proceeding? Or can I have an example of the first voidable enforced by the opinion of the one party? Can I have?
You make some arrangement based on the present law in the country. After 6 months, the law gets changed. You were supposed you were allowed to bring some, import some item, but now they restricted it. So at today, it's valid. At today, it's valid because it's being allowed, but change in law, you are restricted. It becomes void at that time. That time government will say, no, this item cannot be imported. This agreement is void. This is the example. Any changes which are not in your,
Any example happened here?
you have to tell me from construction. I don't think so. Because in our case, change in law is a ground mentioned in extra cost, extra time. So for us, it gives a provision. It doesn't make the contract voidable. Had it not been mentioned, it would have made it voidable. We would have said, no, this is the condition. And there that we will cover in frustration also. Frustration is a situation where you can't do anything. It's more than force majeure.
No,
That we'll discuss.
one thing that, since you mentioned here the turnkey lump sum project. uh, If there is any abnormal changes in the prices, so can the client and consumer shall he go rigid? No, there's a turnkey and you have to execute it, whether the prices are going up the sky or below the floor.
This is the question I was going to ask you just before your break. And you breaked it.
Sorry.
This you will reply. This is the crux of today's discussion, because in this project, what we faced? We faced module prices. Everybody knows. And we were in problem. What are our grounds for that? That is the point where I'll leave the discussion for a break and then I will. Okay. What can be done? There is always a legal rule behind that.
I have one clause also for that.
No, what clause? See,
Not actually clause, but a complicated thing.
keep in your mind, I will ask you that question. You will have 10 minutes of break also to think about that. After that, everybody has to reply. So you took the highlight of my presentation. Okay. Implied condition to fulfill the contract. As we discussed, it should go quick. Bilateral versus unilateral, where the obligations are on both the parties. It's bilateral. When only obligation is on one party and another party is only going to pay for it or giving a consideration. It's unilateral. Simple. Contingent contract. What is contingency? Every time you might have gone for approval, the boss might have said, what is the contingency in this order? What is contingent?
Expected additional things to be happen.
This is with that point of view, but what exactly it is? Contingency is conditional. Conditional. You have to keep that condition. Yes. So contract to do or abstain from doing something if some event collateral or secondary to such contract does or does not happen. What for you want to have some cushion with you in the price? If any extra cost comes, that is contingency. That is contingency. So if anything happens or does not happen, do you have the risk? Do you capture that risk in your pricing? So contingent contract is which is dependent on some situation. Okay. And if that situation is impossible, it becomes an impossible contract. Both are different. So example, A contracts to pay B rupees 10,000 if B's house is burned. If your house is burned, I'll pay you 10,000. This is this type of contract. Valid, void, impossible? Contingent. Contingent. There's a condition. He does not say that give me your house, I will give you 10,000. That will be a normal contract. He says if your house is burned, I'll give you 10,000. So the condition needs to be satisfied for him to get the money. And that is why this is contingent.
All LIC premiums.
Yes. Great. Contingent on uncertain future event. Now there's a twist. Now you need to see whether it is valid or void. Contingent, not impossible, but based on an uncertain future event. What could it be? It is a valid contract. I'm making a contract, I'm making a promise that something in future which is uncertain is happening, I'll pay you the money. It's a valid contract.
Yes.
When it will be valid? But that is not uncertain. Health insurance, the person has to die. It's not uncertain.
No, he did not say term insurance. He said health insurance. You
Yes.
may or may not get health.
Yes. So, but what subject to? Subject to what condition? If that uncertain event becomes certain, the contract is valid.
Just like we faced our module, the container damaged.
Yeah.
That is a part of contract, but it was not certain, it is
Yeah.
unexpected.
Yes. So it was uncertain, based on uncertain event, it was still a contract, and when that uncertain event becomes certain, you'll get the middle. So it is unforceable by law until unless that event happens. But in your case, it's a might different because that agreement is insurance. Insurance comes under different thing. Insurance is a valid agreement. It just captures a risk. Here it says that this is unenforceable. This is voidable that time. But if that uncertain event happens, that becomes valid because that event has happened. There's no impossibility.
Can
No.
LDs come under this?
Why lease? Why lease?
LDs.
LDs. LD is a purely penalty. I'll cover that also. You might have great confusions what LD is, why the supplier is objecting the LD, why he negotiates the LD. As per law, the party who is giving service, he has no right to dispute LD.
Since you said it is an uncertain event, there's no certain that the person will delay.
Okay.
We are putting that term in the contract, saying that if this happens, we will be penalized.
You can say.
So, sir, in other words, even though we are stating it is contingent, in other words, can we see the void? Like we don't know.
You cannot say.
We cannot say.
Because it's not contingent. Now it's a type of contingent. Contingent is not void because the situation, if I say a normal situation, you do this, situation makes it valid. Situation never makes a valid contract void. Remember, uncertain situation makes it a void. You cannot make the sharing of the Taj Mahal and Qutub Minar. We were giving example. Uncertain. It is not possible. Impossible. See, there is always a level. Impossibility, uncertainty. When something is impossible, it is straight away void. It's not a contract. Something is uncertain means it's not certain, but it can happen. It can happen. If that happens, the agreement is valid. Otherwise, it's void. If event becomes impossible, automatically it becomes void. Okay, so you know now that if uncertain conditions become impossible, the agreement is straight away becomes void. But agreement based on uncertainty is voidable because that event is not certain. When the event certainly happens, that voidable contract becomes valid. Okay, clear to all? Example, A makes a contract with B to buy B's horse if A survives C. Okay, A makes a contract with B that I will buy your house if A survives C. Now, survival. C is this contract cannot be enforced by law unless and until C dies in his lifetime. Okay. If he dies after A died, then the contract cannot be done. Right. If he dies, I'll do this. And you die before him. Void. So the conditions should be proper. A contracts to pay B a sum of money when B marries C. C dies without being married to B.
Because promisor doesn't take this. So
The condition has to be satisfied. The lawful condition has to be satisfied. The contract becomes void. The condition is not satisfied. Agreement contingent on impossible event. As I just said, it's void ab initio. The void also have an extension which is called void ab initio. Initio comes from initial. A contract is void ab initio when since starting it is void. There may be two instances that I made a void agreement, so it is void ab initio. From day one it's void. Or I may make a valid agreement, but in future it becomes void because of anything I do, unlawful consideration, unlawful object, I change anything, it becomes void. That contract will be void. So void ab initio is since starting it's void. Examples. A agrees to pay B 1,000 rupees if two straight lines should enclose the space. Possible, engineers? Two straight line meet somewhere. This is impossible. Then this agreement is void.
Two straight lines.
Two parallel lines.
Two straight line. Straight line. It is implied when two straight line is written, it means it's parallel.
Why, sir?
कहाँ मिलेंगी? ये भी straight line होगी ना straight होता है. हाँ?
धक्का मार देंगे फिर उसको.
अरे यार geometry की बात कर रही
no,
है.
it's void. It's void. Actually,
It's a void.
Why?
normally geometry.
Let's not divert the discussion. I'll understand the legality, please. Okay, the agreement is void. A agreed to pay 1,000 rupees if B will marry A's daughter C. C was dead at the time of agreement. At the time of agreement itself, both have different, huh? This and this. This and this. Here at the time of agreement, C is dead. So it is void. Impossible. A dead person cannot marry. So if at the time this becomes a impossible event. Quasi contract. How many electronics engineers there? Timers, quasi state. What is quasi in engineering? Quasi, which does not fixes at one place. It goes here and there. The state is not fixed in engineering. Now in law, quasi contract is, we never thought that we will make a contract. But the incidences happen that way that the contract becomes. Example. Any example?
Shadi.
Shadi, you decide and then you do it.
But जिंदगी में निभाएंगे वो decide थोड़ी नहीं है।
See, मैं ये क्या बात हुआ?
ये contract हो गया ना ये
The
सब-
intention to contract is not there. It
Intention-
happens.
It happens. यही हुआ ना।
When you say, hello, before your marriage, you go and see the girl. Somebody's forcing you to do so. Intention, manifestation of interest. Then the deal happens. When you don't decide,
COVID
Think,
vaccine,
think.
COVID vaccine.
how come COVID vaccine? Tell me?
Like, we have not decided that. Sir.
But you were forced by the law to do it.
Yes.
It was not by default, like by sudden,
Okay.
not driven by your intention, driven by some external force.
Hey, sometimes when we are traveling in a bus, suppose the bus is stopping at some hotel. So one person is going and he will ask others passenger, "मैं सीट बचा कर रखना भाई." It's like a contract. मैं जब तक आता नहीं तो
नहीं, ये contract नहीं है. It's morality and legality. He has no obligation to do this.
Incompleted contract.
It's morality. It's no agreement. You said to him, had he told, I will do it. Are you going to pay him something for that? Are you going to give a consideration? He agrees. It is his liability. You're not going to anything. You're just asking a favor. Please do it. He has not confirmed that also. It's morality. He will do or he may not do. It's his intention. You cannot enforce him to do it. Now coming to that. Any situation or else I will give you.
ऐसे शॉपिंग मॉल में गए कुछ दिखान तो ले आए कार दिखे
कार दिखी तो ले आए मतलब इंटेंशन था ना. अब मैं एग्जांपल देता हूँ. I'll give you example. How many of you order food online? All. Now suppose you ordered food online. I am the delivery person. You live in 101, he lives in 102. I maybe 101 or 110. Okay. So I, by mistake, your pizza I delivered to him. Now he opens the door. I am gone. He's seen the pizza. And that pizza by evening it will be wasteful. Like it has to be consumed. He has not ordered. He has no intention to buy it.
But
What he will do?
eat it.
He eat it. Maybe he thought maybe by somebody by mistake has done this. He will keep it in the house. He will wait for 2 hours. Nobody came. He wait for 6 hours. Nobody came. After 6 hours, he consumed that. Immediately door knocked and I'm here. Said that pizza was delivered by mistake. What he should do? Questions to ask. This is quasi contract. No intention, but you took the service.
by mistake.
Now, is there any liability on you to pay me?
Deny.
It's
No
moral,
liability.
moral intention. You will pay or not pay.
It is a liability as per quasi.
By morality.
Because he has
Not morality, it's a quasi contractual obligation.
This he has to
You
pay.
consumed it. While consuming, you give your consent.
Yes.
Yes.
Other way around, let's.
Consent is with acts also, as he said. Not denying is a consent.
Yeah.
Yes.
India of late, service charges in restaurant has been by the government. They have mentioned that this is not compulsory to be paid. Service charges in a restaurant.
See, as per law, this might be the reason, but as per law, I'm talking about what the provision of act says. The quasi contract, if you enter into quasi contract, you have to pay. Maybe in some categories they can exempt it, but the basic idea is this, that you have to pay.
The rule, the government rule says that you are not supposed to pay service charges at a restaurant.
Okay.
You do not have to pay. While entering the restaurant, there is a board that says that service charges will be applicable.
Okay,
Now I go and I have food and then I say maini dunga.
okay.
Then does it come under quasi contract?
See, on top of everything, all choice, consent, what comes at the top? Law, the law of the country. If it is against the law, you can very well challenge it. If he still asks you to pay, you can pay that time. You can still file the case in consumer law or any specific authority related to that. If it is against the law, nobody is authorized or entitled to go beyond it.
Quasi contract is a part of law, right?
Yeah. So how come it became a quasi contract?
Because it was written inside.
So-
On the.
So what, this is not that. Here you have entered with the intention. I'm saying that the quasi contract, no intention, no manifestation, came consumed, consent only. Only consent. I'm saying since the starting, no intention. You don't want to do it. It came, you did it. Return it if you don't want to do it. So no prior intention to contract. The first condition, you don't want to do it. Offer and acceptance does not exist. Nobody offered you, you did not accept it. You consented. But agreement exists. You took it, agreement exists.
What we, if we throw it, the way you said, I have waited for 6 hours, it is not the food, some other item like phone or something like that.
Understood.
After 6 to 8 hours, I'm like, I don't want to keep this now,
Okay,
I just throw it.
okay, no liability on you. No contract, yes.
Okay.
You have not taken that service. You have not given your consent to accept it.
So I just need to prove that I have thrown it.
Yeah.
Sir, one more thing. Khara ho sakta hai, isliye maine khaya bola.
If I throw it,
You give a consent, huh?
He will ask this question.
You took the service, right?
I was
You
waiting.
took the service. It was not free of cost.
Yes, yes. One more. If some bike or car is there, something,
Something like
unfortunately,
that.
someone thrown on that car or bike, it is damaged. It is damaged. So whether we need to pay.
You tell me what this act is. If I send something on your car, it is broken.
Unfortunately.
It's not unfortunate. It's a wait.
It falls something.
Unfortunately,
Yeah.
okay. There is always a thing behind it. If I do it, do I have intention? Do I have intention to do it? In your case, there may be two things. One is intention. Intention is straight away penalty. Other thing is a topic of tort. What it may be. I don't have intention, but I did it. What it can be. What it can be. I did something wrong, but I was not having an intention. And it costed the party. It made him a loss. It's negligence. Negligence is that isn't taught. Because generally these happens against the society. You did something. You blocked the road. You made something wrong to the public. That is the part of tort, which we'll discuss in the next part. But if you do something, the example that somebody hit a chair, he sent the chair out from his balcony, it hit the car. Now he can say, I did by mistake. He has to prove that there was no intention. Then it's a case of negligence. If he prove that there is an intention, then again there is a compensation as per the civil
Only
procedure.
something is there that fall, that car.
What?
Some flower pot.
Negligence? Why you are hanging the flowers in the society? What? It is you are responsible. Who asked you to hang the flower pot outside your balcony? Is it right way? Do you have the right to hang it there? You have right to do whatever you do in your balcony, not outside your balcony. If something moves out of your balcony, you should be vigilant.
Whether that comes under this class.
Taught.
or-
I'm saying taught. Whatever can happen to anybody is taught against society, against public. Because there is no contract. If you do so and his car is damaged, you say, I don't have any contract with him. Why you should pay him? From where he will seek the remedy? He will go in tort. No contract, but it is your duty. Negligence, public nuisance, defamation. This all is taught. That we'll see. There are 2 slides for that. Natural justice. The principle is what? You consume the pizza, you should pay. It's a question of morality, not the legality, although it's legal as per the quasi contract. But